Hello, I'm Sam Beighton, a partner in the competition antitrust team at Gowling WLG. And what I wanted to touch upon today were some recent developments in competition law, focusing in particular upon cooperation, collaboration, and then giving some concluding thoughts in relation to these hot topics. So without further ado, I wanted to touch first of all upon cooperation. And the reason for flagging this in the context of supply chain is thinking about some of the challenges being faced. I think, as we are all aware, we have a perfect storm. We have a perfect storm of shortages, production issues, increased demand as we all emerge from our COVID cocoons. And this is resulting in higher prices. And that's, I think, for people, particularly in the UK, but also other economies worldwide, I think that's just an unescapable fact of everyday life now. We are all seeing higher prices, both business and in our personal lives. This is filtering through the supply chain. So I think what's important in that backdrop is the well-known quote that in the midst of chaos, there is also opportunity. So there are concerns that these challenges are giving businesses opportunities, and those are opportunities to collude. That could be further increasing prices. So prices have gone up already, and perhaps the current crisis then gives a further opportunity to perhaps put a little bit more on top of that price. Or if the conditions that led to higher prices perhaps have subsided, there is an opportunity for businesses to collude to maintain those increased prices at a level where they would otherwise have dropped away. So against this background, what we are seeing now is an increased scrutiny from international agencies, and in particular, the Five Eyes competition authorities. So the competition authorities in the US, Canada, Australia, New Zealand, and the UK, the Five Eyes countries. And what they have recently put together is a new working group. And this new working group is focusing upon, perhaps unsurprisingly, supply chains. And what this working group is doing is developing and sharing intelligence amongst these agencies. And the goal of the working group is to detect and investigate suspected collusion. So this is international level cooperation amongst agencies focusing upon possible competition issues in supply chains. And this is a significant build upon an existing memorandum of understanding entered into between these authorities. We now see the bonds between them being strengthened by this working group. And I think what we can expect from that is obviously greater scrutiny of supply chains and supply chain conduct. I think what's also useful to flag as well from a UK perspective is we have also seen, despite Brexit, we have seen continuing cooperation between the UK and the EU in relation to competition issues. So we had a recent tech sector investigation opened into Google and Meta. And recently as well, we saw coordinated dawn raids taking place at multiple sites across the UK and the EU, investigating suspected concerns in relation to recycling of end-of-life vehicles. I think on top of that, what we are seeing in the UK is a competition authority in the CMA, which perhaps has a backlog to clear. Obviously, as the world has been affected by COVID, dawn raids have not been a viable option for authorities. What we are now seeing are investigations beginning to pick up. We had 3 investigations starting in March, one of which was the end-of-life vehicle investigation, which, as I said, saw the multiple dawn raids. I think we can expect to see more, as we have an authority in the UK that clearly is working through a backlog of cases and is now actually able to go and conduct investigations. And I think what this then means for businesses is, inevitably, it had to happen at some point. Dawn raids are back on the table. So for at least 18 months, 2 years, I think that has fallen down the list of concerns. The notion that an authority could arrive in reception obviously was not happening when people were working from home. What we now have is an environment where we have authorities actively investigating. And I think what this then means for businesses is, well, I think the first question is, in this brave new normal we find ourselves, are your old procedures still fit for purpose? If you have the flow charts, the contact sheets from the old world, are they still where they should be? Have you had new people join? Have you had people leaving the pandemic? Are the right people in the right places on your own internal processes? And secondly, would your business know how to respond? So if there was an investigation that started and you had an authority in reception, would your business know how to engage with that appropriately? And it may well be that your business has in place training and the people you had pre-pandemic are still in post and in position. But for a lot of businesses, there has been a good deal of movement during the pandemic, and perhaps people who have joined maybe don't have the same level of understanding of what needs to take place in the context of an investigation and how to best protect the business's interests. So there's a question there about what we now find ourselves in with greater scrutiny, dawn rays back on the agenda, just making sure in the available time that businesses have themselves up to speed in terms of responding and having procedures in place that are fit for purpose in our new normal. That's cooperation. And I want to then just consider a little bit the issue of collaboration. And by collaboration, I'm thinking here about issues in the context of supply chain where competitors have interactions which potentially could then spark the kind of concerns that down the line would lead to an investigation. So just risk awareness and horizon scanning by reference to some recent developments. And the first I wanted to touch upon was the Commission decision in relation to car emissions. And as you may all be aware, this is a case that attracted a good deal of publicity. The focus of the competitor collaboration was to reduce emissions in relation to new diesel cars. And what the circumstances of the case comprised were 3 competitors actually collaborating very, very successfully. They collaborated, they worked out a new means by which to reduce emissions for diesel cars. And this was a really good thing, a really pro-competitive outcome. 3 competitors working together, combining resources to devise something new, innovative, that actually delivered in terms of benefits on a product. Where things then went off piste is the fact that competitors then limited the technical development of the system itself. And we'll touch on that in the coming slides to see how that unfolded. By way of background though, and I think this is worth flagging as technical as it's going to get, the system which was devised uses a liquid, AdBlue, to reduce emissions. Because it's a liquid, and this is liquid going into a car, there needs to be a tank to hold the AdBlue. So the system then requires a tank to go into a vehicle. The tank needs to be refilled at regular intervals by the user as the AdBlue liquid is used. This then presents a number of questions which relate directly to user and consumer experience. Do you have a big or a small tank? If you have obviously a big tank, then all else being equal, you can go longer before you have to refill that tank. If you have a small tank, then you don't have as far. You have a shorter range on that. So if you have a small tank that needs refilling more often, is that something that consumers would welcome or not welcome? It's perhaps a cold winter morning, you're out there with a funnel and a bottle of AdBlue trying to fill up your car. Would you wish you'd had a bigger tank, or does this not matter to you? Another question, which again fits into the refill question, is how much AdBlue do you use? So if you have a small tank and you are using a lot of AdBlue, then that's going to require obviously more refilling. So the tank and the use of the liquid does have a bearing upon user experience. What the parties did, they agreed to use small tank sizes. This then meant they understood the cars would have shorter refill ranges because of these smaller tank sizes. And they also signaled to each other the intended AdBlue usage. And the usage that was indicated was on a meet not beat basis. So they could have used more AdBlue, they could have exceeded the standards, but they indicated their intentions were to simply hit the standards, not exceed the standards, hit the standards. What the competitors did not do, and I think this is worth flagging as well, they did not introduce uniform tank sizes, they did not introduce uniform refill ranges, and they did not introduce uniform cleaning strategies. So amongst the different offerings, there was variation, observable variation amongst the offerings. However, By exchanging information on their future intentions, the Commission held that this removed uncertainty. It avoided competition on solutions. Nobody was going out there with a big tank strategy and they were going to max the AdBlue usage and really push the emissions down. There was not competition being engaged with on solutions. And then this removed the risks resulting from divergence. This was therefore seen as a by-object restriction and was fined as such. And in this context, there was no requirement for the Commission to prove any actual effects upon competition. One party was leniency applicant and therefore avoided a fine. The other two parties were fined a total of 875 million euros in the context of this particular infringement. But I think another noticeable facet of this case is that the competitors had actually sought to ensure compliance with competition law. They hadn't set out as some kind of clandestine cartel deliberately seeking to achieve ends that were known to be against competition. They had tried to ensure compliance. They actually set out rules of engagement, and the rules of engagement included that there would be no discussions of issues that were relevant to competition. And the emission system itself wasn't really seen, it would appear, to be seen as relevant to competition by the individuals engaging in the development. I think what we do then find in the decision is that this position that the emission system is not an aspect of competition is then undermined by internal documentation and public statements. So what does this case tell us? What are the learnings from this? I think it raises a really key question for in-house lawyers about the repositioning of risk in relation to competition law infringements. So I think that people will be well aware of price fixing, market, customer allocation, bid rigging as all areas where clearly competitive interaction is going to be problematic. But this notion of technical development and the possibility of limiting technical development, I'm not sure is as squarely on people's radars, but I think following this case, it really should be, because I think this shows a direction of travel in relation to competition enforcement, that these sorts of instances, I think we can expect to see more in this area, where there have been discussions between competitors, perhaps seeking to find collaborative solutions, but then there has been a crossing of a line, which has led to a reduction in competition in relation to a customer-facing aspect of that product or service. I think also it's important just to flag that the parties, despite seeking to avoid competition issues, it almost reads from the decision as they almost kind of designated something as not being an issue. And I think it's important just to raise there that parties themselves obviously cannot opt out of competition law. Parties can't decide amongst themselves to designate something as not a competition issue and leave it as such. Competition law would obviously still apply to that. I think the last thing to flag, and I think this is again perhaps a theme we will see emerging as I talk about some HR issues, is I think we are increasingly seeing a need for in-house lawyers to reach into parts of the business where perhaps competition law hasn't always had a foot. And in this context, I think it is useful for in-house lawyers to be able to reiterate to working group members, if they have individuals in the business working in these sorts of competitor collaboration groups, that it's really important not to reveal plans or intentions to any of their counterparties at competitors. So obviously, discuss the approved terms of reference, what's there to be covered, but going beyond that and opening up discussions about plans or intentions, it clearly should be off the table in that context. I think a point to raise as well is how this then feeds into, as a topic, another area where there has been considerable interest in recent years in the competition arena, and that is the question of when competitors can work together to achieve outcomes that support sustainability in sectors. Within the UK, we have now had the CMA's advice to the UK government being published. What we see from this advice is there is a clear intention from the CMA to provide further guidance. And I think this is obviously to be welcomed by parties. Further guidance is always going to be more helpful than no guidance. What we can expect to see from this is, I think, safe harbour in the first instance. So some more clarity around when competitors can perhaps work together without those agreements restricting competition when they're working for sustainable outcomes. But also when it comes to the individual assessment of arrangements, greater clarity from the CMA about how to apply exemptions from the Chapter 1 prohibition. So thinking about the benefits generated by sustainability agreements and how the benefits can be shared and how you demonstrate a fair share of those benefits flowing down to consumers and end users. So I think we will obviously await the guidance with interest. There will be, I'm sure, gaps and aspects that will invite further clarity. But I think that to have this coming is welcome, and we can expect to see more in this area, because I think with the increasing pressure with regard to the climate crisis, the idea that people could now perhaps work together to achieve better outcomes is clearly one that's going to be with us for the foreseeable future. The last point that I wanted to pick up in relation to collaboration was around recruitment challenges. And this is something which we've seen a number of industries facing, I think, real and very costly competition for talent. And this has led to some circumstances where businesses have perhaps sought to neutralize some of that competition. One way of doing that has been no poach agreements, whereby parties would agree with each other not to hire employees from each other. Another angle on this is around wage fixing, where perhaps parties in the same sector would agree amongst themselves a level, a banding within which they would pay certain salaries for certain roles. What's interesting is that in the US, we have recently seen criminal prosecutions. So back in 2016, the US issued guidance around HR issues, competition law, no poach wage fixing, and why this was going to be problematic. We saw a year or so ago a criminal prosecution started in the US. We've recently had in the EU, Commissioner Vestager saying that no poach and wage fixing agreements are like buyers' cartels. So this is seen as, from an EU competition law perspective, also problematic. Within the UK, we've not yet had a statement or case around these types of issues, but I think we can expect the CMA to align closely with the Commission position that these would be seen as serious infringements of competition law. And I think even putting that to one side, for businesses above and beyond, there's clearly the reputational damage. If your company was involved in this type of arrangement, that could itself present challenges for recruitment going forwards. So again, picking up on the theme of perhaps in-house lawyers reaching into parts of the business where they haven't necessarily done historically from a competition law perspective, I think this is one of those areas which lends itself to that focus. So if you are engaging with HR, I think there is a question there about current policies, having discussions with staff, confirming to people that the business must act independently, and that obviously no poach and wage fixing type agreements are simply not permitted or accepted or tolerated within the business. I think if you are there in HR having these sorts of conversations, it's probably worth doing some risk assessment as well of any benchmarking exercises. So if there are benchmarking exercises that take place around salaries within your organization, is it a third party who's preparing a confidential data set, or are your HR colleagues speaking to their counterparts at competitors or sector participants, trying to ascertain who pays what, what's the salary banding, are you going to increase it this year? That's useful to get a handle on at the outset. And then another aspect to consider is whether there is benchmarking taking place, what are the outputs? How granular does this get? Do your HR people have a very good oversight in perhaps quite a small market of what your competitors are all doing? Or is it the case, actually, this is by a third party, it's aggregated and anonymized outputs, and there isn't a competitional risk involved with this? I think where things are moving with this issue, I think this is an area where we'll see further developments, further investigations. I think there's a window now for companies just to take stock of where they are and ensure that they are complying with the requirements at this stage in proceedings. I think then, just to conclude and just to pull together a few of these threads then, as I said at the outset, what we are seeing is international cooperation between agencies actively being promoted with a view to focusing upon issues in supply chains, as well as within the UK itself. The CMA is still working closely with the EU and obviously having its own investigations that it's launching. Dawn raids are back. I think that's an unavoidable fact of life now. Dawn raids are back, and businesses, I think, just need to factor that back into their thinking. We are seeing a focus upon what I would call new areas of competitor interaction. So the traditional cases will always be there, but I think we are now seeing competition law enforcement reaching into different areas where businesses perhaps do not realise they currently have a risk in those areas. And I think what this then lends itself to is an opportunity now for businesses as they return from the pandemic and as they get back into a rhythm of hybrid working in this new normal, an opportunity for businesses to review and refresh their current procedures and policies around competition or compliance, mindful of the current circumstances we find ourselves in. Thank you.